So far you've already have the idea of who are promoters and their functions. And now let's move on with the pre-incorporation contracts section. Pre-incorporation contracts are those were made by the promoters before the company was formed. That is the simplest definition for the pre-incorporation contracts. You can find a much more detailed definition in section 51 of the CA 2006. A contract with purports to be made by or on behalf of a company at a time when the company has not been formed has effect, subject to any agreement to the contrary, as one made with the person purporting to act for the company or as agent for it, and he is personally liable on the contract accordingly. So, what can you draw out from such definition? The first note we can draw out from the above definition is that when the company is registered, it is not bound by the preliminary contract because at the time the contract was entered into, the company had not yet come into existence. It was the promoter of the company who entered into the contract, not the company. So whoever signed the contract is bound by the contract and would be personally liable, notwithstanding that the company may have attempted to ratify the agreement. It means that in some situation, after being registered, the company may try to ratify công nhận the agreement. However, that is not a legal way to make the company become the party to the contract instead of its promoters. The more legal way to do so can be found in the second note. The person who is made liable under Section 51 can avoid personal liability by a clear agreement on exclusion of personal liability with the other party to the contract. You can find an example in the case of Phonogram Ltd v. Lane. The third note we have here is that a company may not become a party to a pre-incorporation contract by ratification. Therefore, the person who is the signatory to the contract, not the company, can enforce the contract. Don't let yourself misunderstand that promoters are seen as agents of their company, so the company can enforce the contract. The relationship between a promoter and the company is compared to the relationship between an agent and a principal, người đại diện và người được đại diện. However, we cannot apply the doctrine of agent and principal into the relationship of a promoter and a company because the company didn't exist at the time of pre-incorporation contracts were made. And so the company was not the real principal at that time. So after being incorporated, the company cannot enforce the contract. The final note shows you the only one way that a company can become a party to a pre-incorporation contract by novation. Novation is a tripartite transaction in which the parties to the original agreement together with the company enter into a new agreement. And the case of Howard v. Patton Ivory Manufacturing Company is a very good example for this. Part 3 of this chapter deals with the Articles of Association, điều lệ. We usually assume that the Articles of Association is the only constitution of companies. However, there are a wide range of documents that can be counted into the constitutional documents of a company. So from this list, you can see the Articles of Association is just one type of constitutional documents of the company. Here are some important notes that you should pay attention to. The first note is that all constitutional documents, decisions, and agreements must be registered with the Register of Companies. Failure to register all of these documents can be considered as criminal offenses. The second note is that not all kinds of shareholders' agreements have to be registered. Only the agreements that fall within Section 29 of the CA 2006 have to be registered to the Register of Companies. And the final note is that the most important constitutional document of a company is the Articles of Association. The Articles of Association may be supplemented or even be changed by shareholders' agreements. And now let's take a look at this definition of the Articles of Association. As you can see here, the Articles of Association deals with the internal management of a company. So the company's owners are the one who is in charge of deciding the contents of the articles. It means that owners of companies are free to design the outline and fill in the contents of the articles. However, in many situations, they decided to use the model articles. As for the model articles, there are different sets of model articles for different types of companies. These operate as the articles of a company to the extent that they have not been excluded or modified. It means that companies' owners are free to change or to adjust the contents of the model articles so that the article are more suitable for the conditions of their companies. The effects of the Articles of Association. Section 33 of the CA 2006 states that the provisions of a company's constitution bind the company and its member to the same extent as if they were covenants on the part of the company and of each other to observe those provisions. So, the Articles of Association is considered as the statutory contract, and the company is the party to this statutory contract. This is not just a contract between each member and the company, but also between each member and each other member. As I said in the previous slide, the Articles of Association is considered as a statutory contract. So for the next couple of slides, see for yourself the characteristics that distinguish the statutory contract from a typical contract. Here is how the Articles of Association can be amended. The rules of law governing the amendment of Articles of Association can be found both in the CA 2006 and in case law. According to Section 21 of the CA 2006, a company may amend its articles by special resolution. You will have further details on special resolutions in Chapter 4. For now, just note that special resolutions often require big amount of votes. There are some exceptions to the above rule. Some matters in the Articles of Association that do not require a special resolution to be amended, and you can find these matters in Section 551 and 685 of the CA 2006. As you can see from these two sections, the matters here only require an ordinary resolution to be amended. Ordinary resolutions only require the majority of votes. You can also find in case law a principle relating to amending the Articles of Association in the case of Randhawa v. Turbin. The duomatic principle was applied where the shareholders unanimously but informally agree to amend the articles. It means that in this situation, all of the shareholders in the company agreed to amend the articles. However, the process of amending the articles was not carried in a formal way. But under the duomatic principle, the agreement by 100% of shareholders in the company was enough, no matter how formal or informal the process was. Besides statutory provisions in the CA 2006 and the rules in case law, there are some contractual provisions that can affect the amendment of the Articles of Association. The first type of these contractual provisions is called entrenched provision of the Articles. Section 22 of the CA allows the articles to contain some specified provisions that are more restrictive to be amended or appealed than the provisions applicable in the case of a special resolution. So here we can understand that special resolutions are not enough to amend entrenched provisions, but only conditions or specific procedures have to happen so that these entrenched provisions can be amended or repealed. The second type of contractual provisions can be found in company contracts. Basically, a company is not allowed to enter into a contract that restricts its power to amend its articles. If it does, it can still amend its articles because nothing can restrict the company's power to amend its articles. However, doing so means that the company is in breach of the contract, so it has to pay the remedy for the other party to the contract. The remedy here is damages, and damages means compensating assets or compensating money. The third type of contractual provisions that can affect amendments of Articles of Association is shareholders' agreement. And the fourth type is court-developed restriction on amendment. So be sure that you spend some time on reading these cases. I am not going to check your reading in the final test or in any other test. So just make sure that you spend some time reading these cases for your knowledge. And now let's talk about shareholders' agreements. Generally speaking, shareholders' agreements are usually entered into when the company is first registered, but may be entered into at any time. They may or may not be a part of the official constitution of the company, but either ways can fundamentally affect the way a company is managed and controlled. Shareholders' agreements are often entered into to provide clarity to the enforceability of the Articles of Association. A shareholders agreement can be confidential. However, if a shareholders agreement falls within Section 29 of the CA 2006, it becomes registrable to the Register of the Companies and available for public scrutiny. Shareholders agreements are principally used by the shareholders of closely held companies. Closely held companies are companies with a small number of shareholders. In contrast to closely held companies, shareholders agreements are not common in companies with a large number of shareholders, because with a large number of shareholders, it is really hard for the shareholder to come into an agreement together. One more thing to notice too is that there is a wide range of matters that can be addressed in shareholders agreements. The most common matters are appointment of director, shareholders' rights and liabilities, and the issue of shares in the company. For the next 2 slides, to see for yourself the parties to a shareholders agreement and how to enforce shareholders agreements.